Myself is Dr. Atul Mathur. I am professor in IIMT Engineering College, Greater Noida. Today's my topic is meaning, significance and essential elements of a valid contract according to Indian Contract Act 1872. What is Indian Contract Act? The Indian Contract Act is one of the oldest mercantile law of our country. It came into the effects on the 1st September 1872 and is applicable to the whole of India with the exceptions of Jammu and Kashmir. Containing a total of 266 sections, it is the principal law regulating contracts in India. A contract is an agreement between two parties that creates an obligation to perform or not to perform a particular duty. A contract is an agreement that specifies the certain legally enforceable rights and obligations pertaining to or more mutually agreeing parties. A contract typically involves the transfer of goods, services, money, or a promise to transfer any of those at a future date. In the events of breach of contract, the injured party may seek judicial remedies such as damages or recessions. A binding agreements between actors in international law is known as treaty. According to the definitions of authors, the Pollock, every agreement and promise enforceable by law is a contract. According to Salmon, a contract is an agreement creating and defining the obligations between two or more persons by which rights are acquired by one or more to act or forbearance on the parts of others. Now, after examining the definition of contract, we can say that in agreements there are two words. The first one is offer, second one is acceptance. Yani ki first one is offer, and second one is offeree. That is acceptance. It means agreement means offer plus acceptance. But in the nature of contract, there are three words. The first one is offer, the second one is acceptance, the third one is enforceability. So that we can say according to contract, the agreement plus enforceability. And if we can say that all contracts are agreement but all agreements are not contract, so it is a right concept. According to illustration, A contracted with B for purchase of 100 bags of wheat of a certain quality for rupees 30,000. In this case, B's promise is to provide A with 100 bags of wheat of that quality only for which A has contracted, and A promise is to duly pay B rupees 30,000. In this case, both have performed something for the others, thus it is a case of reciprocal promises. So it is a contract. According to section 10, there are few conditions for the contract. The first one is offer. Firstly, there must be an offer from the either party. Without an offer, a contract cannot arise. The second one is acceptance of the offer. The offer must be accepted and accepted by the person to whom it was intended. So, an offer by A to B has to be accepted by B only. Acceptance in ad idem. Thirdly, though acceptance is important, there must be consensus ad idem. Consensus ad idem means meeting of mind. It means that party to the contract should accept the terms of the contract in the same sense. Thus, party to the contract must have the same understanding of the term of the contract. Example: A contracted with B to purchase mango. Now, A wanted a special type of mango, however, B though of it is to be a normal mango. In this case, although there is a valid acceptance, but There lack meeting of mind between the parties, the meeting of mind concerning the types or quality of mango. Similarly, if A contracted with B to buy the stock, what A meant was stock in a company, whereas B is understood it to be his livestock, it means farm animals. In this case, the understanding was not in the similar sense. The parties must be competent to contract under the law they are subjected to. They must be legally capable to contract. The consideration. For the performance of promises, there must be a consideration, something giving for performance of promise from both parties to the contract. Further, the objectives and consideration of the contract must be lawful. Free concerns. According to section 10 of the contract act, agreements are contracts if they are made by the free consent. It means that contract must be entered into out of parties own violation and without being forced or deceived into. There must be an intention to enter into a legal relationship. Certainty. Contract must be certain and not ambiguous and vague, according to section 29. A contract must not be expressly declared void. Section 10 of Indian Contract Act. There are some essential elements of the contract. If anyone is absent, so we can say that there is no contract. The essential elements of a valid contract. The first one is proper offer and acceptance. There must be at least two parties. It means there two parties must be in the contract, one making the offer and other accepting it. Such offer and acceptance must be valid. An offer to be valid must fulfill certain conditions, such as it must intend to create legal relations, its terms must be certain and unambiguous, it must be communicated to the persons to whom it is made, and acceptance to be valid must be fulfill certain conditions, such as it must be absolute and unqualified, it must be made in the prescribed manner, it must be communicated by an authorized person before the offer lapses. So these are the main terms and conditions for a proper offer and acceptance. The second term is intention to create the legal relationship. The requirement of intention to create legal relations in a contract law is aimed at shifting out cases which are not clearly appropriate for court action. Not only every agreement leads to a binding contract which can be enforced through the court. For example, you may have an agreed to take a friend for a movie for dinner. You may have a moral duty to honor that agreement but not a legal duty to do so. So that if these types of contract, it is not called that it is a contract and it is not enforceable by law. This is because in general the party to such agreement do not intend to legally bound and the law seek to mirror the party's wishes. In order to determine which agreements are legally binding and have an intention to create a legal relation, the law draw are distinctions between social, moral, domestic and religious agreements and agreements made in a commercial context. There must be an intention among the parties to create a legal relationship. In case of social or domestic agreements, the usual presumption is that the party do not intend to create legal relationship. But in commercial or business agreement, the usual presumption is that the party intend to create legal relationship unless otherwise agreed upon. Example: X invited Y to a dinner. Y accepted the invitation. It is a social agreement. If X failed to serve dinner to Y, Y cannot go to the court of law for enforcing the agreements. Similarly, if Y fails to attend the dinner, X cannot go to the court of law for enforcing the agreement. The third one is capacities of party. As per the requirement of section 10, the party to an agreement must be competent to contract. In other words, they must be capable or competent to enter into a contract. If either of the parties does not have the capacity to contract, then the contract is not valid. According to section 11 of Indian Contract Act, 1872, every person is competent to contract who is the age of majority, according to the law to which he is subject and who is the sound mind, and is not disqualified from contracting by any law to which he is subject. Therefore, other way round, following persons are incompetent to contract. The first one is minor. Minor means the person who have not attained the age of 18 years. The second one is persons of unsound mind, and the third one is persons disqualified by law to which they are subject. So, the persons to be competent to contract must be major, must be sound mind, must not be declared disqualified from contracting by any law to which he is subject. If the party to agreement are not competent to contract, then no valid contract came into existence. The fourth one is lawful consideration. An agreement must be supported by lawful consideration. The consideration means something in return. In the words of Pollock, consideration is the price for which the promise of another is brought. The consideration is known as quid pro quo, something in return contract. Act not only requires a consideration, rather it prescribed for a lawful consideration. According to section 23 of Indian Contract Act 1872, according to which the consideration is considered lawful unless it is forbidden by law or is of such a nature that if permitted would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or is immoral, or is opposed to public policy. Example: A agrees to sell his car to B for rupees 1 lakh. Here, B's promise to pay rupees 1 lakh is consideration for A's promise to sell the car, and A promise to sell the car is consideration for B's promise to pay rupees 1 lakh. The fifth one is lawful object. The object of an agreement must be lawful. According to section 23 of Indian Contract Act 1872, the object is considered lawful unless it is forbidden by law of such nature that if permitted it would defeat the provisions of any law, it is fraudulent, involves an injury to persons or property of any other. The court regards it as immoral or opposed to the public policy. The sixth one is free consent. There must be a free consent of the party to the contract. The free consent of all the parties to a contract is also one of the essential elements of a valid contract. As per the requirement of section 10, the party to a contract should have identity of mind. This is called consensus ad idem in English law. Two or more persons are said to consent when they agree upon the same thing in the same sense. Consensus ad idem. It means that there is no contract if party have not agreed upon the same thing in the same sense. Further, Contract Act requires not only consent but a free consent. According to section 14, the consent is said to be free when it is not caused by coercion. Second one is undue influence, fraud, misrepresentation, mistake. Next matter is agreement not expressly declared void. The agreement must not have been expressly declared void under the provisions of section 24 to 30 of Indian Contract Act 1872. For example, agreement is in restraint of trade, also marriage, legal proceedings, and agreement by way of wagers have been expressly declared as void under the Act itself. Example: X promised to marry none else except Y, and in default pay her rupees 50,000. X married Z, and Y sue X for recovery of rupees 50,000. It was held that Y was not entitled to recover anything because this agreement was in restraint of marriage and is such void. The next point is 8th point, certainty of meaning. The term of the agreement must be certain and also unambiguous. According to section 29 of the Indian Contract Act 1872, agreements the meaning of which is not certain or capable of being made certain are void. The 9th point is possibilities of performance. The terms of the agreement must be such as are capable of performance. If the act is impossible in itself, physically or legally, it cannot be enforced at law. According to section 56, an agreement to do an impossible act is void. Example: A agrees with Y to discover treasures by magic and Y agree to pay rupees 1000 to X. This agreement is void because it is an agreement to do an impossible act. Example: Second, X agree with Y to enforce some area between two parallel lines and Y agrees to pay rupees 1000 to X. This agreement is void because it is an agreement to do an impossible act. The last point is legal formalities must be complete. The agreement must comply with the necessary formalities as to writing, registration, stamping, etc. If any required, in order to make it enforceable by law, an oral contract is a perfectly valid contract, but not in those cases where writing, registration, etc. is required by some statute. But in India, writing is required in cases of sale, mortgage, lease, and gift of immovable property. Negotiable instruments, memorandum, and article of association of a company, etc. Registration is required in the cases of documents falling within the scope of section 17 of the Registration Act. Example: an oral agreement for arbitration is unenforceable because the law requires that arbitration agreement must be in writing. That is bibliography. Thank you.